All right, well, we're going to get started. Thank you all for coming and joining us for our discussion on regulatory threats to flexible employment and entrepreneurs. My name is Trey Kovacs. I'm a labor policy analyst at the Competitive Enterprise Institute. And for you guys who aren't familiar with CEI, we're a nonprofit public policy organization dedicated to the principles of limited government, free enterprise, and individual liberty. We work in 5 main issue areas: labor and employment, energy and environment, finance, technology, and regulatory reform. We implement an all-purpose strategy of doing research, coalition building, outreach, and litigation when necessary. So that's a little bit about CEI. And then our labor project is focusing on the Department of Labor and National Labor Relations Board overreach, which is the topic of our event today. And we're going to basically go over how the Obama administration's regulatory onslaught is trying to turn back the clocks of time to a time of corporate giants where it's very hard to start a business and very few workers were given flexible schedules. And so basically these costly regulations threaten to seriously disrupt workplace and common business relationships that help grow the economy. And obviously now is not the time for more costly and complex rules on job creators. There's millions of workers who are seeking full-time employment but can only get part-time work. And labor participation rate is near an all-time or 38-year low. And so, unfortunately, we know the reason why these labor federal agencies are issuing these regulations and these different initiatives, and that's to ease union organizing campaigns, which is an unworthy goal and puts job creation and workplace freedom at risk. And it's important to remember that the Department of Labor and National Labor Relations Board were not created to promote big labor. They were created to advance workplace opportunities and to protect workers, which during the Obama administration, pretty much the opposite has been going on. So it's up to Congress really to rein in these federal agencies and put them back on their mission to create opportunities for workers instead of propping up special interest groups. And so that's what we're going to talk today, is how Congress can do that. And really, Congress has the power of the purse, and they can defund some of these initiatives that are, that stray from the mission of the Department of Labor and National Labor Relations Board. And that's what our panelists are going to discuss, some of these initiatives that Congress should really consider defunding. And one of the issues that we're going to talk about is the National Labor Relations Board joint employer decision, which makes a company responsible for the actions of another company that they don't have any control over, which is a threat to entrepreneurs who want to get into business for themselves. Another issue that we're going to discuss is the Department of Labor overtime rule that dramatically increases the minimum salary threshold for exempt workers of overtime. And then we're going to hit on the worker classification issue where the Department of Labor is stringently enforcing employee classification, which is going to limit workplace flexibility and independent contractors. So I'll introduce our panelists now. We have Eli Dourado, who is Research Fellow and Director of Technology Policy Program at the Mercatus Center, which is part of George Mason University, and he's also a PhD candidate. We have Bob Dorfman, who is a franchise owner of World of Beer, and previous to that, he owned several Five Guys restaurants as well. And then we have Angelo, Amador, who's Senior Vice President and Regulatory Counsel at the National Restaurant Association. And so we'll start it off with Bob.
Great. Thank you very much. To be honest, I kind of know why I've been invited here today. I've been honest to myself. It's because you're all expecting that I'm providing happy hour after this discussion today. I wish that were the case. In any event, my name is Bob Dorfman, and as has been mentioned, I was a pretty large Five Guys franchisee back in 2006, 2012. I operated 35 Five Guys in 3 states, Florida, Ohio, and Texas. And we were very successful, and we had over 700 people that we employed. which we felt was also very special. And now I'm a World of Beer franchisee in Virginia. I have an operation in Charlottesville, Virginia that's been open for about a year and a half, and I have another location opening up in Ashburn this coming month, next month. Just kind of by means of background, and I'm sure many of you are familiar with this whole joint employer issue. Last August, there was a 3-2 decision on the part of the NLRB involving a company called Browning Ferris Industries in California. And then the National Labor Relations Board redefined then its standard for determining what joint employer status was. And in its decision, the board found that Browning Ferris was a joint employer with a company called LeadPoint. LeadPoint was a staffing agency that was providing services to their recycling facility. The case itself actually arose out of a Teamsters election in 2013, which at that time they were seeking to represent the staffing agency's employees at Browning Ferris at the recycling facility. At that point, if the union were to win, it would again be entitled to bargain with both Browning Ferris and a staffing agency jointly. And that in of itself is a serious problem. Prior to the board's decision regarding Browning Ferris, under decades-old legal precedent, 2 employers are found to be joint employers. This is going back now, even today. 2 employers were found to be joint employers only when the 2 entities exerted such direct and significant control over the same employees that they shared or co-determined matters governing the essential terms and conditions of employment. Relevant factors in making this assessment included, for example, the right to hire, terminate, discipline, supervise, and actually direct the employees. And in applying this test, administrative agencies and courts generally found that the control exercised by the putative joint employer must be actual, direct, and substantial, not just simply theoretical, possible, limited, or routine. In Browning Ferris, the board majority rejected the requirement that the joint employer's control be direct and immediate. The decision will have a significant impact on businesses for the first time in decades. The board considered indirect control to be the main factor in determining whether a joint employer relationship existed under the National Labor Relations Act. The board overruled, which was a long-standing precedent to achieve this result. A long-standing precedent that made no sense in their determination that would achieve this result. The National Labor Relations majority has imposed a never-before-seen test that extends far beyond the congressional intent of the National Labor Relations Act, far beyond that. The new standard of Browning Ferris requires the board, on a case-by-case basis across multiple industries, to inject itself into complex business relationships, the structures of which are completely unrelated to labor relations, The NLRB's redefinition of joint employer is merely an excuse for other motives that make no sense and has a potentially devastating effect on franchisees and the successful franchise model overall, a franchise model that's existed for 100 years and has caused people like myself to become and want to become small business person. Organized labor is seeking any opportunity to increase its diminishing relevance in today's economy. And one of the bodies of influence that it has enlisted to support itself is the U.S. Congress. This redefinition of who an employer is may well eliminate what's been the benefit of franchising. So what's the NLRB's argument that they believe constitutes joint employers? Where 2 separate legal entities share the ability to control or co-determine essential terms and conditions of employment, such as hiring, firing, disciplining, supervising, and directing employees. There are at least 3 cases that have been in the courts, 2 of which have been adjudicated, 1 which is still pending adjudication, the most notorious of which is the McDonald's case. And that's still, again, pending judgment. Two other cases, one in 2013 and 2014, one involved Domino's and one involved Massage Envy. Both of those cases, given the criteria that were involved in those actions by the NLRB against those companies, actually the judgments were to the benefit of the companies and not the NLRB. The problem in this case is that the NLRB is a loose cannon, and so it's this unknown whether or not any of these cases, including the McDonald's case, is going to be adjudicated to the benefit and the favor of McDonald's and its franchisees. That's the scary part of it. You just don't know where the NLRB is coming from on these issues. None of much of my previous involvement with Five Guys, for example, nor my current involvement with World of Beer as a franchisee came or even comes anywhere close to justifying a redefinition of joint employer. I had, and I still have, absolute control over my working conditions. They include hiring, firing, disciplining, supervising, providing direction, establishing compensation and incentives, as well as any benefits I provide. I have absolute and direct control over all of those in the current situation I'm in with World of Beer today, as I had with 7 years with Five Guys. That's just the model that franchising provides. Local franchise business owners hire and manage their own employees, period. That's just the way the franchise model works. Moreover, we run our own businesses, and we have direct control over our own hiring practices, working conditions, wages, and our own hours of operation. We have distinct employer identification numbers. We file our own taxes, and we're responsible for following all applicable local, state, and federal laws. That's what we do as small business owners. A franchisor has no direct control over the hiring, firing, discipline, supervision, and direction of its franchisee employees, period. The National Labor Relations Board, though, is changing the legal definition of joint employer to satisfy its own desired outcome and draconian motives to insist that franchisor and franchisee are joint employers. We're not. This whole thing is preposterous. These are pro-union, anti-small business, anti-company laws changed or created by the National Labor Relations Board. That's what they are. And the National Labor Relations Board has defended its joint employer decision by stating that franchisors have too much control over the independent franchisees that they contract with for them to be considered their own operations. Are they kidding? It's just not the way it is. If this redefinition of joint employer is not stopped dead in its track, I personally will have to look to halt any further development and expansion of my business, not because of the additional liabilities, for example, financial and otherwise, that it would impose on me, but because it changes the entire franchise model that's been so successful in the United States. That's what I signed up for as a franchisee. And it eliminates the entrepreneurial benefits that it provides for the millions of small business people like me. What a shame it would be for me and my business and the potentially hundreds of people that I could be adding into the workforce. If you and your representatives believe in the importance of supporting and encouraging small business owners in this country, which I believe you all do and the people whom you represent do as well, which include franchisees and those who wish to become small business owners, then I ask you for your help and your support to ensure that the statutory definition of the term employer is not redefined and that you support us enforcing the NLRB to rescind its redefinition of joint employer. The entire franchise model, a foundation of what has been part of the small business enterprise forever, is clearly in jeopardy. Thank you.
Well, thanks, Bob. All right, Angelo, speak about the overtime rule.
I'm going to speak about the overtime rule, but before I do that, I want to add to what Bob just said regarding the joint employer. One of the problems is that the new definition is really obscure. It's really not a definition at all. You know, the NLRB says that they're going to look at it on a case-by-case basis, and one of the hardest things for employers and for restaurants that are so prevalent in the franchise industry and others is that they need clear guidelines to figure out what is it that can be done and cannot be done in order to, be a joint employer. And, those rules have been clear for decades, and this change that goes case by case really throws in a monkey wrench as to, how to do your contracts and how to have those relationships. So I think it's very important that we fix that. With regards to the Department of Labor, the overtime regulations, again, I cannot speak for all the other industries, but I'll tell you what the impact will be for ours. The definition that they're looking, the amount, the threshold under which people will not be getting, will not be considered salaried employees, is going to have a real regional impact. So when we went to our restaurants and we did a survey as to how much they paid their assistant managers, when you look at places like New York City and San Francisco, those places will not be affected. So from the start, and we saw this from nonprofits, counties, universities, they have all share their concerns that regionally, when you look to other states, I mean, what $50,000 gets you in New York City by comparison to what $50,000 gets you in Mobile, Alabama, where I went to one of the hearings, is completely different. So, it might affect our assistant managers are making more than that in New York City. A manager at a bank in Mobile, Alabama might be making less than that. So for starters, the threshold itself, is trying to it regulates the entire country. It's a high amount, and it also turns the definition of overtime on its head. Right now, the way it's supposed to be defined is a threshold under which everyone should be an hour employee, as opposed to a threshold over which no one should be receiving overtime. And so we have very big concerns with that. The department itself, the president issued the memo, executive order memo, to the Secretary of Labor asking him to review the overtime regulations in March of 2014. The NPRM, the proposed regulations, did not come out till June 30th, 2015, and then we were only given 60 days to comment. Even the government, the Small Business Administration Office of Advocacy, asked for more time to review the proposed regulations, to do the economic studies on its impact, and the Department of Labor said, we're not going to give you more time. We're going to move fast with it, and you guys had enough information. So even though it took them over a year to come up with a proposal, we were given 60 days to review. The impact is going to be large as well, because in our industry, we have low profit margins of 4 to 6%. So benefits we're not reaching benefits. However, if you're a salaried employee, you get a lot of benefits that are usually not given to hourly employees, like, for example, the vacation, sick leave, and others, in addition to the fact that you are on track to becoming a manager and moving further up. If you change those individuals to hourly employee, you will lose those benefits. And more important for our industry is that a lot of people come to our industry because of the flexibility. And when you're a salary employee, you tend to have more flexibility. If you need to pick somebody from school or something like that, you're able to leave and come back, and you will still get paid for the hours, whether you work them or not. If you are an hourly employee, the employer has to track the hours. You have to be on the clock. And I'll tell you, I was an hourly employee, and I never viewed me becoming a salary employee as a demotion. I think when you ask the employees, they usually view it as a promotion. I mean, they want to be on that managerial track. So the regulation seems to go the other way. It has a couple of other provisions that the administration is saying they may or may not include, such as a duties test, which means even if you make $50,440 a year, we're going to look at your duties as well, and we're going to track them. So in essence, you end up having to track the hours. For our industry, again, it is difficult because hopefully you all have been to restaurants, and you will realize that, as we say, in our industry, even the managers sweep floors. Even the managers, will stop by and say, "Hey, do you want some water? Is everything fine here?" And they will help, particularly when it gets busy. So if you start having to track whether, wait a second, that manager was sweeping the floors or serving water for somebody, you need to track that because that's a hourly task. It's going to become very difficult because when you become a manager, part of your task, as all managers will tell you, is to show everybody else that you're willing to do it and you're willing to lend a helping hand to everyone else. So it's going to become very complicated in our industry. And at the same time, we believe that it's not going to be, the costs have to come from somewhere, and I don't think it's going to be, at the end of the day, beneficial for the employees as well, that lose the flexibility and lose the benefits that they get now being salaried employees. What can Congress do? I don't know. Right now, the rule hasn't come out. I know that in your paper you talk about the Congressional Review Act. I hope that if it is as drastic as some of the proposals, that they come back with another proposed regulation as opposed to final regulation, because there's a lot of concerns. And there's concerns. I was listening to a panel just a week and a half ago of counties and nonprofits. This is a big deal, not just for businesses, but it's a big deal for anybody that has payroll. And I know that universities are very concerned, and I know that small counties and cities and nonprofits across the country are very concerned with the level. But even more importantly, I think sometimes people concentrate on the easy or the most spoken issue at hand, which here is the amount. But there are a lot of other things that are very, very troublesome for everybody. The duties test being one of them, and other restrictions in the regulations. So, Congressional Review Act would be one. But I think right now, writing to the Department of Labor, which a lot of congressmen are doing, whether you're doing it on behalf of business or whether you're doing it on behalf of nonprofits or universities, we don't care. But write to the Department of Labor and tell them, to take a second look, because this would be would have dire impact on all employers in the United States.
All right, thanks, Angelo.
Thank you.
All right, we're going to end with Eli.
Thanks, Trey, and thanks to CEI for the invitation, and thanks to you all for coming. I'm delighted to be here. At the Mercatus Center, we've done a lot of research on the sharing economy, and of course, the sharing economy raises a lot of issues in employment, about the role of employment law in the modern world. Are Uber and Lyft drivers employees? Should they receive benefits? How should overtime be handled? How about drivers that work for both companies? And so what I want to do is talk at a high level, set a little bit of context for that question. Because these are labor trends that begin well before the sharing economy was created or existed. So Airbnb was not founded until 2008, and Uber was not founded until 2009, right? So let's think about what's going on before that. So the Bureau of Labor Statistics puts out data on traditional employment every month, right? What everyone wants to know is how many jobs were created, right? So 4 days ago, they had a release for January of how many jobs were created in January, and the headline number was 151,000. So what most people don't realize is that this is a net number. This is not how many jobs were created. This is how many net new jobs were created. So every month, millions of people are hired, and millions of people separate from their employer. So it's about 5 million people starting new jobs or leaving their jobs every month. So when the BLS reports how many jobs are created, what they do is they take the number of new hires and subtract out the number of separations. And so when they report 151,000 new jobs created, it's probably like something like 5.15 million new jobs created and about 5 million jobs destroyed. So there's actually a huge amount of churn, surprising amount of churn in the labor market. And the term in the economics literature that we use to discuss that is called dynamism in the labor market. So dynamism in the labor market is a very, very important thing. Dynamism means that the economy can absorb shocks better. So something surprising happens, people lose their jobs. How is the labor market going to be able to adjust quickly enough? So let me give you some examples. There's a near universal agreement among economists that trade is good. Trade is, great in the long run, but it has to be said, in the short run, it's a shock to the labor market. If we have a dynamic labor market where many millions of new jobs are being created every month, then the labor market can rapidly adjust when the shock hits. So if we introduce trade with China, and some people lose their jobs, many millions of new jobs are created every month, and then those people are able to find work again quickly. It might still be difficult to lose a job, but a dynamic labor market limits the damage from those shocks. On the other hand, if new jobs are created more slowly, right, then people could be out of work for a long time. And this has a huge social cost, right? It ruins people's lives. I mean, I have friends who, were unemployed for a long time, and they have very difficult. Their marriages suffered. Their stress levels are terrible. So there's a huge psychological cost to the labor market not being dynamic. It's the same thing when there's a shock to technology. Let's say that someone invents a burger flipping robot, right? And this takes thousands of people out of work. As long as there are new jobs being rapidly created, we have all the benefits of cheaper burgers plus labor market opportunities for everyone. If it takes forever to find a new job, then we're going to have displaced workers for a long time, and that's bad for everybody. So what I worry about in the labor market is the decrease in overall dynamism. So since the 1980s, the gross amount of new job creation and destruction has been falling as a fraction of the labor force fairly consistently since the 1980s. So the labor market is becoming less dynamic over time. And that means that shocks to the labor market from trade or from technology are taking longer to work their way through the system. So losing a job is a bigger deal today than it was in the past. So for many people, it will be harder than ever to find a new job. So for decades now, the traditional labor market has been getting less dynamic, and at the same time, the labor market has been getting somewhat weaker. It's been experiencing shocks, lots of shocks from trade, lots of shocks from technology. Of course, there was a financial crisis. So what are people to do? So my colleague Chris Koopman and I have done some research on this, and we requested data from the IRS, which we received, on the 1099 workforce. So the idea here is that a lot of the sharing economy developments have not been captured in the traditional BLS surveys, but part of that is because people get asked, are you working? Are you an employee? And they might say yes, even if they're working for Uber, right? And they're an independent contractor for Uber. So the survey data isn't that reliable. So what we wanted to look at instead was tax data. So we looked at the number of people who are engaging in contract labor and receiving a 1099 form versus the number of people who are involved in traditional employment and receiving a W-2 form. Probably most of you receive a W-2. So what we find is that since 2000, there has been a 22% increase in 1099s. So huge increase since the year 2000 in 1099s. During the same period, there has been a 3.5% decrease in W-2s. So this is a pretty dramatic shift in what's going on in the labor market. 22% increase in contracting and a 3.5% decrease in traditional labor. So so just some observations here. The increase in contracting cannot be due to the sharing economy. Right? How do we know that? Well, because the increase started in 2000, and the sharing economy firms weren't even around until 2008 and 2009, right? So the increase began earlier. So what's going on? So what I think is that the decline in dynamism in the traditional labor market, since the 1980s that we discussed, because of that, people are increasingly having to find non-traditional forms of labor because of that decrease in dynamism. So they find contracting. Contracting is something that gets them around the decrease in dynamism in the labor market. And as the demand for contract work has increased, so the sharing economy firms happen to have thrived, right? So they came around after to build on this momentum. So what I worry about is what happens if we increase the burden on sharing economy firms? What happens if we continue to increase the burden on traditional firms? Well, one, I'm worried that we're going to make the contracting market as non-dynamic as the labor market has been, right? So it's going to destroy a lot of opportunities for people. It's going to make it hard to let people. People are using the sharing economy as sort of a release valve for the economic pressure that they find themselves under because of the stagnant labor market, and so I think it's going to really harm people if we increase the burdens on sharing economy firms, or even if we continue to increase burdens on the traditional economy firms. So what should we do instead? I think instead of creating additional burdens, we should try to address the root cause of this decrease in dynamism in the traditional labor market, and that means removing burdens on traditional employment. Do something about the benefits that keep people locked into jobs. We want to make it easier, the labor market more fluid, so maybe taxing benefits, removing occupational licensing requirements, and allowing for more flexible arrangements for all kinds of employment, as my panelists discussed, not just the sharing economy. And I think that by making the entire labor market more flexible instead of less flexible, we can make the economy and American households more resilient to the shocks that we see in the modern world. And so my worry is that instead, labor market regulators are going to do the exact opposite, contributing to the decline in labor market dynamism and excluding people from the workforce and harming countless lives.
Well, thank you, Eli.